Muhammad Nazif Azli. My metric number is 288788. Before I start presenting about subject of the international law, I will make some introduction about what is actually subject of international law. In any legal system, certain entities, whether they be individuals or company, will be regarded as possessing rights and duties enforceable at law. Thus, an individual may prosecute or be prosecuted for assault, and company can sue for breach of contract. They are able to do this because the law recognizes them as legal person, possessing the capacity to have and to maintain certain rights. They are able to do this because the law recognizes them as a legal person, possessing the capacity to have and to maintain certain rights and being subject to perform specific duties. Just which person will be entitled to what is right, in what circumstance, will depend upon the scope and characters of the law. Now we move towards past cases, which is Rainbow Warrior cases that happened in 1985. The Rainbow Warrior cases is actually, the summary of the cases is actually in July 1985, a team of French agents sabotaged and sank the Rainbow Warrior. Rainbow Warrior is basically from Greenpeace campaign network, which are conducting about anti-whaling, anti-seal, and anti-nuclear testing. Rainbow Warrior, a vessel belonging to Greenpeace International. While it lay in harbour in New Zealand, which is Upland Harbour, one member of the crew was killed. Two of the agents, Major Mafat and Captain Prior, were arrested in New Zealand and having pleaded guilty to charge of manslaughter and criminal damage. And both of them were sentenced by a New Zealand court to 10 years in prison, but France demand the release of the two agents, and New Zealand, which claimed compensation for the incident. New Zealand also complained that France were threatening to disrupt New Zealand trade with the European communities unless the two agents were released. Summary of the cases, the Rainbow Warrior cases. The two countries actually requested the Secretary General of UN, which is United Nations, to mediate and to propose a solution between two of them, which both parties agrees. The Secretary General ruling, which was given in 1986, require France to pay $7 million US to New Zealand, and to undertake not to certain defined measure injuries to New Zealand trade with the European communities, which is basically France must not do anything about the New Zealand trade. That's what the solution given by the United Nations. And one more thing, what happened is actually UN also said that both of the captain and the Major Mafat must be in the custody and spend the next 3 years on an isolated French military base in the Pacific. Both of the major and captain must spend their 3 years in the prison if they want to repatriate, or if they want to bring back both of them to their custody in France. And both of the country agree that 3 years must be in prison and must be compensated to New Zealand. But what is actually happening in these cases is that after not more than 2 years, the first one, which is Major Manfaat, is actually having a medical heart problem, and not more than 2 years actually, on 23rd July 1986, because of the Major Manfaat heart, the team advised that he must be evacuated to France for treatment on 10 December 1987. Following concern about Major Manfaat heart, a French medical team advised that he must be evacuated from the prison to France for treatment on actually 10 December 1987. But what is actually happened is that both of the countries have a treaty or agreement, which is both of them must be in prison for 3 years. But because of the Major Manfaat condition, they're asking about urgent heart-related transfer without having a consent of New Zealand. Captain Prior was repatriated in May 1988. The French authorities notified New Zealand that she was expecting her first child and asked consent to her repatriation. But New Zealand again requests that an independent medical examination must be made for her, which is the medical checkup from New Zealand doctor. And both of them are agreed, but actually One day before the New Zealand doctor came to France, Captain Priya's father was dying of cancer that her immediate evacuation had thus become necessary. She was repatriated one day earlier without the consent of New Zealand and never returned to prison. From these cases, what is actually the relation between these cases, which is warrior cases, and the subject of international law itself? I can say that the capacity to resort the customary method recognized by international law for establishment, preservation and settlement of claim, which is in this case because of the aberration and liquidation towards French to settle the conflict. And one more thing is because non-state subject, which is it is actually the non-governmental organization, which is Greenpeace, because NGO are one of the subject of international law. They have the right and duties, which is the treaty between France and New Zealand to make sure that both of them must be in prison for 3 years, but France cannot fulfill the treaties, which is they have the right, which is New Zealand have the right to claim the justice. Lastly, because New Zealand can claim the breach of international law, which is to bring international claim. That is actually what is connection between subject of international law and these cases, which is warrior cases.
Moving on to the second case, it's Nottebohm case. Let me tell you who is Nottebohm. He was a very wealthy businessman for German that lived in Guatemala over 3 decades. Sometimes he visited Liechtenstein for his brother. But then, of course, in Guatemala with his other brother to proceed his business such as coffee plantation, sea and banking. And when the World War II happened, he went to Liechtenstein and applied citizen of Liechtenstein, or we call the naturalization process. Then he went back to Guatemala and he was being arrested for 2 years in the prison in the United States. And while he was in prison, all of his asset of company and business was being seized in a very large amount by the Guatemala and United States. But then let me tell you, when the World War II happened, the President of the United States, the President Roosevelt, had announced that every German citizen are alien enemy, meaning if you are a German citizen, you will be arrested. And this is the weird part, because Mr. Nottebohm had already changed his citizen, right? So the Liechtenstein, after the Mr. Nottebohm had been out of the prison, of course they took the responsibility by suing the Guatemala, saying that their action by arrest him while he was already changed the nationality. But the Guatemala argued back, said that we will not identify this person as a Liechtenstein citizen because first, he does not fulfill the terms of naturalization, meaning you do not know the culture of the specific country, you never lived there for a long term or at least 3 years. And other than that, it's very obvious that he applies this neutral position by applying citizen neutral state, because Liechtenstein does not involve in the World War II. So think about this. If he live in Guatemala with his German citizen, of course he will be arrested. So Nottebohm thought he immediately changed his nationality from the Liechtenstein and he went back to Guatemala and everything will be okay and save his business. But then it will not do that way because Guatemala will still act this person German citizen. And obviously after the World War II you apply that, it's quite late, isn't it? And what does the court say? Of course the court says yes to Guatemala because of course there's a sovereign right to every its own citizen. But then for this case, Liechtenstein are inadmissible on the ground for the Mr. Nottebohm case. This case related to the subject of international law and more specific, individual. So Mr. Nottebohm requests the individual rights to the Liechtenstein to protect him as their citizen, but it does not valid since I mentioned earlier is the reason why the Liechtenstein does not have the right to protect Mr. Nottebohm. So for our conclusion is this topic behavior can gather different views and aspects to accommodate to grow the field of international law. States do play important role, but the increasing prominence of individuals, international organizations, and non-state entities cannot be overlooked. As for today, modern era, international law play their role by solving global issues. Sum up, today's topic has been in their role by going through the process and responsible in regulating the conduct of all subjects that is encompasses and the entire international arena.